Good morning. I hope everybody's doing well in this time of COVID. I'm trying to hang on as best we can. Update, I was going over the notes for the, well, thank you for being with us, sorry. This is to follow up on the malfeasance, misfeasance, and what's been going on with this case. And it's a public interest because this has to do with every disabled person. Anybody being represented, the way they're doing business in Ontario, it appears. I was going over my notes the other day, and the first appointment that I went to at Onyx was February 8th, and March 10th was the date that I went to Benton Street Medical, and I have been refused treatment at both places for arbitrary reasons. My only guess could be, and also it's traumatizing. It's one of the biggest trust relationships you could ever have. But it just goes to show the extent that they're able to play. Like, they're communicating between each other because they're all connected to the municipal government. Ministry of Municipal Affairs and Housing. So anything to do with planning of housing, they're supposed to be proactively in there, acting on behalf of all people. So how's the old folks' home going? What's going on here is exactly what's happening at every other building in Ontario. They're given free passes, and the long-term care homes are the same as this landlord here. It's a system. So I don't want to get off topic. I just want to say, I'm trying the best I can, and I'm not sure if I'm going to make it. And I'm looking for people to please speak up. Please help us to defend ourselves. And when I say ourselves, I mean all of us. Anyway, getting to it, I looked up in Webster's Dictionary what the definition of a prison is. And it's a noun. The collegiate definition, which that means is that collegiate definition means basically the accepted definition across all dictionaries, all understanding. So, based on the noun, a prison is 1, a state of confinement or captivity. So, the state of being confined or captive. And 2, of course, a place of confinement, especially for law breakers. Specifically in institutions such as one under state jurisdiction for confinement of persons convicted of serious crimes, compared to jail. So it's from the dictionary, so it's saying basically, look at the definition for jail, it's basically the same thing. But let me draw your attention to that. It says, such as one under state jurisdiction. So this supposed legal aid system and system of defense is under state jurisdiction. It is all run, when it comes to disability management, it comes under Arch Disability Management, and the government have come up with a system of connivance. It's a cyclical system that this proves all they do is go back to the same people abusing you. And the purpose of those people abusing you is to keep you confined and contained by not allowing the proper dissemination of proper facts or even allowing it as evidence in a venture, because we, next door 100A, when this started, gave them the whole thing. Public records, everything, to show what was happening. And they booted us out anyway. There was a point where there was actually a reprieve, and then somebody pulled it, because again, all they did was they took all that information about what is lawful and what is unlawful here, and just like when you look at the videotape series, you will see them. No person is allowed to give misinformation. That especially means Shane Turner, which is the Director of Municipal Service Enforcement in Waterloo, Shamir Maida, Allison Hensall, the fire inspector, the chief of the fire department that allowed this to happen, because there's no checks and balances. You're paying for services where they're not doing them. That's what we documented here. They gave them a rental license, sight unseen, and even while they're in the process of going through it with next door. And they're pretending that the two are not connected when it's the same landlord. But look at the public record, because it is clear what they're doing. They're not following the law. Again, this should never have gotten to landlord-tenant. It should never have had to go through Waterloo Council how many times? How many times have been referred back to write it down? We all are. I'm a person with a disability. Okay? But let's talk about that. What does it mean to be disabled? It's an adjective under the collegiate definition. Disabled means 1A, impaired or limited by a physical, mental, cognitive, or developmental condition affected by a disability. So decades of governance, government policy, and Supreme Court decisions. Oh, this is a statement as to what that's about. It says decades of government policy and Supreme Court decisions have established that public services for all disabled people must be provided in the least restrictive and most integrated environment possible. So has this been least restrictive? The City of Waterloo Legal Department is so afraid of what they got exposed for that Steve Ross, the solicitor for the City of Waterloo, was either fired, removed, or not renewed his contract. He is now working for another private law firm here in Waterloo. Why he is able to practice at all? Well, I mean, here it is. It's a system of containment, right? So Steve Ross, we've been trying to do this, and Steve Ross has lost his job. Because Steve Ross, like I said, as I pointed out, on one hand, council is making the rental license bylaw that is to protect especially persons with disabilities. That's the sales job, and it's to protect the taxpayer because they assured this law is to make sure that landlords like this cannot operate in this environment unless they are acting by the law. Let me remind you, the law states unequivocally and clearly it is the Ministry of Municipal Affairs and Housing that is responsible to maintain and uphold the law, not divert it for its own purpose. The law is what's written in the books, and no person means you, Minister Clark, you, Premier Ford, you, Solicitor General, you, Attorney General, and especially when it comes to the ramifications of what we've uncovered for possible land, tax, fraud, and manipulation of the system. Again, a system of containment. 1B for disabled also says incapacitated by illness or injury. But what's most important here is what they put down as number 2. Disabled of a device or mechanism rendered inoperative as by being damaged or deliberately altered. And I would say that that is the one that fits the most, the disabled part that we're trying to get past the government. Because the government and this system of connivance is the device and mechanism that is rendered us inoperative. Because we are notwithstanding. No matter what we do, no matter what rightful, lawful evidence we give, it is not good enough. And I have gone to the Tribunals Ontario, which is all under the purview of the municipal affairs. And that's how they're communicating, because I told them the last communication I had with them was this doctor refusing me treatment. And the system in general, because again, he's bringing up whether he's my primary caregiver. Political issue, which had no place to be there, and and it's ridiculous anyway, because he's the doctor providing the services. Who's the primary caregiver? The fact is that the government has not established a clear defined protocol that is already law. The doctor decides. It's interfering with doctors to cover their ass. That is the problem. And look at the stories that came out with pandemic. What are the doctors saying? Why is it difficult to counsel government? Because government is a lie. Government is not here to protect anybody else but its own interests, and that is what this is showing. Notwithstanding is in the Constitution, which nullifies the whole Constitution. Because anything that they decide to do is notwithstanding. Well, like I said, we handed them their own records, which they should have been. They're required to police their own records. They knew what was going on here. They had an incident at this specific address, cleared the house out for the landlord, and then let them refill it again. All under a rental license. The promise to the taxpayer was that This, you get a rental license, it's like a car. You went in for a safety, you got it checked out by a guy, it was safetied, here it is on the road. So if they're allowing a garage to do this to cars, would they not stop them? But the reason why they're not, you have to ask the reason why they're not. The reason why they're not is because they just treat everybody that they don't care to deal with as notwithstanding. Then they hide behind judicial immunity. Because I've gone through the whole process, and even with everything that's gone on, everything provided for them, they came up with, but there's nothing you can do because it's judicial immunity. Where I had to point out, I'm sorry, that is incorrect, because judicial immunity, or any kind of immunity, first of all, you must be acting lawfully. All persons are required to act lawfully. That includes the Justice Minister, the Attorney General, Solicitor General, all lawyers, all colleges and schools that are required to train these people. Arch disability management must act lawfully. We all are, right? Judicial immunity is only covered if they are acting in good faith. On good faith starts with you must be acting lawfully. So if the landlord's acting unlawfully, and again, look what's happened. It's there. All we did was post the truth, and I'll tell you. Anyway, notwithstanding is a legal term for disabled within the system. For example, nothing stated or submitted is considered as notwithstanding. In other words, no say in the proceeding covered by judicial immunity. So the rules, the way to get this go around in order to do this ex parte thing, they are required to send the documents directly to you from the ministry. And then the person doing the application is required to send you anything else that they're required to use in the hearing 5 days before the hearing, not the day before. When I went through and checked our records, there is no less than 3 of these last applications by the same landlord for the same property under 2 different names, because he does it under Commissions Worldwide one time. Oh, we got something on him, let's withdraw. And like I said, we put in our evidence. They accepted our evidence in that matter. November 4th, they did it as Atlas Property Group, and the reason why they withdrew that record is because they closed down shop and closed permanently. While Mark Koenig, the Chief Financial Officer of Atlas Property Management, now sits there and writes a letter to us saying, oh, it's Koenig Holdings taking care of it now. So it looks good on paper, doesn't it? It all looks good on paper. You need to look below the surface at what's going on. But that is misrepresentation and fraud. Mark Koenig, as Chief Financial Officer of Atlas Property Group, submitted falsified documents. Knowingly misrepresented documents, we called him on it, and the letter is going to be posted here. And the ministry and everybody knows what's going on, and whether they do or not, they're supposed to be impartial. All that is required to get a proper inspection of a rental property is the leaseholder saying, I would like it inspected, please. That is the way the law says is all required, and show evidence that there's a problem. And then all they're supposed to do is come in, and from top to bottom, they come in with their form, and they go, here it is, top to bottom, what constitutes lawful? And they go through that as a standard, and here's all the points, and again, sorry you missed it, but that's the whole point of this process, is to go, sorry you missed this, here's all the stuff that has to be lawfully corrected to bring this into lawful compliance in order to lawfully provide a rental license that shows that this is a lawful standing, a building with lawful legal standing as of the moment it gets rented. And that is what we were promised as tenants, as taxpayers, as people who uphold the law. That is the line. That's to be done before we even move in. Nowhere in any of these laws does it say that a tenant is responsible for any damages for anything done unless they were the ones that caused it or their guests. But how do you know that if the standard's never been maintained? It's a lawyer who handed him an unlawful contract and is trying to defend him in it, when it is a standard residential contract. There are standardized things that these agencies could do to make it less problematic for everybody. Number one, you do it in order, because again, here you have one property, same issues, multiple filings on their behalf. It's at least 6 times they charged their $179 or whatever the hell it is, and we've responded and tried to, and been trying to, but they know the answer. That's why they're stopped. They got the answer next door when we did it there as an association. But the association is notwithstanding. They just, well, we don't need to do that. That's getting in the way of what we're doing. This is a business deal. We have commitments to our willing partners. So they obstruct justice. And they mock. They mock everybody. Again, this is a pandemic. Before this, go look at the series before the pandemic. They're all like, we don't know what's the right department to enforce. Oh, you got to talk to regional government. No, you got to talk to city. No, you got to talk to province. No, you got to talk to this guy. Well, you didn't get the right guy, so here, let's keep you running around. And regardless of AOTA, and again, 20 years of Accessibility Ontarians with Disabilities Act, Arts Disability Management is the sole proprietor of committee in implementing the Committee for the Rights of Persons with Disabilities. They claim to be doing it since 2016. They've taken awards from disabled being harmed to put in their fund to help this system of containment. Let me remind you, everything Hitler did while in government was lawful. It was done through the Municipal Act. Just like this. Let me ask you, how many psychiatrists are there in Canada for the whole of Canada? You need to go look at that number. Look at this invented crisis of ICU beds, because it's based on a cost outweighs benefit ratio, which, does that not say, you know, you don't call it profit, but when cost outweighs benefit, that means you're eating into profits, right? In a non-profit, equal opportunity healthcare system where nobody interferes with your healthcare and the doctor reigns supreme, because the doctor is the one by law that says what your condition is or whether you're disabled or not. And after all these years of disability, you know, that no government level on any level has gotten a department together that says, you know, they've got a disability, social services, paid out through crazy, but it's not. The federal government has been advised that I've been disabled since 2004. Provincial government too, but every department is not the sum of their parts because they get to charge for services. And it's one more layer of obstruction. And it's not, what did it say? It says, decades of government policy and Supreme Court decisions already bought and paid for. Precedent. That's why it doesn't work in tribunals, because tribunals do not have to follow precedent. So even if I prove this in a tribunal, the next person comes in and goes, oh yeah, well, that's different. But there's no continuity. The only continuity is they could mess with everything and not face any consequences because they got judicial immunity in their opinion. You were talking about they're interfering with my ability to get treatment, and then they're communicating with them when to do this ex parte thing to hit me when I'm down. When it shouldn't be happening at all. But it says here, decades of government policy and Supreme Court decisions have established that public services for all disabled people must be provided in the least restrictive and most integrated environment possible. They do it, and whatever they want without license, and this is blatant. So I mean, take a look. I invite you to take a look at what's going on here and open your eyes to the ramifications of what this means. Because this is active participation of the administration in overruling and obstructing their own laws, and overruling and obstructing the proper collection, the proper assessment of and collection of proper taxes and or penalties and or fees. They did not even charge him under the rental bylaw. That's why they are so afraid. Meanwhile, if you're infringement of one bylaw, you're infringement of all of them. So if you're infringement of the property standards, you're infringement of the fence if there's a fence involved, you're infringement of the partition fence if it's involved, you're anyway. It's all the same. I didn't write the laws. You didn't write the laws. We didn't tell them how they're supposed to do it, but they're sitting there breaking the rules to circumvent to cover up what they're doing. What do you call unlawful? So they cannot cover malfeasance and misfeasance. Malfeasance is again, let me see for a sec, I got it here. Misfeasance on the part of, oh, that's sort of my note, sorry. I mean, this is ridiculous. All they do is they use you. They play with you. We're their plaything. Misfeasance in public office is knowingly engaging in unlawful conduct. Unlawful is a very specific word. It means you're either following the law or you're not. But there's some sort of gray area in there because it's them. And we're all equal under the law, right? They don't have to follow the law, but we do. Malfeasance in public office is when public office holders acts or fails to act in a way that constitutes a breach of the duties of that office. Minister Clark, it is your duty to make sure that every building is maintained to the minimum standard. You cannot just slough it off. You keep telling us, change the law. But you have to go to legislation to do that, right? It's called accountability. You cannot cover malfeasance or misfeasance protected by obstruction in a system of connivance to control and contain rather than defend and disable, defend disabled. We've all been disabled, not just us. Taxpayers have been disabled from proper representation. Equal representation under the law that they wrote and signed, while they're going in the other side of sales and contracts to do these undermining decisions, which can be tied to RIM, can be tied to Mississauga scandal, because it's about lawyers and a legal system of connivance. This is controlled by lawyers. And the thing that they did to me in that courthouse, like, I did nothing wrong. We are the ones who are acting lawfully, and yet I'm the one in prison. To the point where, George Floyd, who's that? No, all respect. The point is, this isn't about me. I don't have a future. You guys have been clear to me in 17, 18 years where the hell I feel. But you're the one who's making a mistake. I know what I'm worth. I know my value. You can keep trying to tell me what my value is, but you're wrong. You're blind, and you're tainted. You're delusional, following a delusional person who thinks that they rule the world. What's your definition of slavery? What's your definition of freedom? If we're free, why are our hands tied? And hey, go pay for a lawyer. Michelle from Rosemount, you paid your fees. Everybody pays their fees. Everybody goes along, plays the game. It's a legal issue. Get it? Disabled for proper representation of the individual. I am an